Hello, welcome to another episode of Police Encounters. Today we're going to have our third and final discussion on the topic of police encounters while in a vehicle. We're going to discuss the more nuanced and advanced issues that sometimes present themselves in a police encounter while in a vehicle. Welcome back. I'm Brett Knight. I'm an attorney here in the state of Tennessee with the law office of Fry, Knight, and Looper. Today we're going to have our third and final discussion on the topic of police encounters while in a vehicle. If you've not been able to join me in the other two previous portions of this discussion, I would encourage you to go ahead and do so. In episode 1, we talked about the basics of a police encounter. In episode 2, we talked about an escalated police encounter up to including arrest. And today we're going to tackle some more nuanced, advanced issues that sometimes present themselves during a police encounter in a vehicle. So what kind of advanced issues are we talking about? Well, one of the big ones is a search. Search of the vehicle or search of a person that's based upon a stop or a police encounter in a vehicle. And the topic of search and seizure is a complicated one. It can seem basic on its surface. We can talk about what the Fourth Amendment says and how it protects us and gives us protection against any unreasonable search and seizure. That seems pretty basic. But then I could sit here for 2 hours and talk about search and seizures and exceptions to that and what's reasonable and unreasonable in court cases that have kind of fleshed this out over the years. So we'll try to keep it narrow to just police encounters in a vehicle searches, and we'll hit it with a little bit of a broad stroke, but with as much detail as we can, given the kind of time frame that we're going to be in on this video. Of course, we'll have other videos where we talk about searches in homes and of documents on computers, phones, but for today we're just going to talk about the police encounter in a vehicle searches. So how does that present itself? Well, it usually presents itself when the officer simply asks, "Can I search your vehicle?" And then as we talked about in episode 1, my advice is going to be no. The answer should be no. You can't search my vehicle, and we talked about that again in episode 2, the reasons why. But let's talk about when they can search your vehicle absent your consent. Now, if you're given consent, I mean, I've already advised against that. If you're given consent, then there's no constitutional issue at play, and none can be brought up in court later. Usually there can be no issue brought up at a hearing or in court unless you are coerced in some way. But if you give consent, you give consent. We've advised against that. I've advised against that. So we're going to assume then that you followed that advice and you've not given consent. And we need to see under what circumstances can the police search my vehicle or me or my items during a police encounter without my consent. So, Constitution protects you against unreasonable search and seizure. So, the exceptions to that would be, one, obviously a warrant. The police can go to a judge or a magistrate and get a warrant. They could, articulate the reasons why they believe some evidence of criminal activity will be found, and they can get a warrant, and then they can search without your consent with a warrant. That's the biggest exception. And that's what the law says. Without a warrant, there can be no search other than with your consent, unless it falls within one of the exceptions. And that's where we can spend a lot of time talking, is there's lots of exceptions. One of those is any kind of an exigent circumstance. That is a circumstance where the police are in hot pursuit and they're chasing somebody, and then the person jumps into a vehicle. It doesn't really apply so much with what we've been talking about. But they can talk about, if something's in clear sight, what we call a plain view doctrine. If there's some evidence of illegal activity, it's in plain view. I can see a marijuana joint sitting on top of the console, or I can see, some other sign of illegal activity sitting in plain view. Then they're going to be allowed to search, and get those items based upon plain view. Another one that we often see is with vehicles is an inventory search. What an inventory search is, it's not really an exigent circumstance. It's kind of a workaround. If I'm being arrested, let's say for example, I'm being arrested for DUI and the vehicle is being towed, the police are allowed to do what they call an inventory search. That is, they're allowed to look through the items in the vehicle for the purposes of inventorying those items to protect those items from being lost or stolen or not being able to be presented back to you. However, I will tell you, it is often an abused reason to search somebody's vehicle, and I've had many hearings over that. I've even had circumstances where an officer does an inventory search of a vehicle and then never tows it, which of course is an illegal search. And we have what's called an exclusionary rule, which says that any items found illegally by law enforcement cannot be used against the defendant under most circumstances. So there's inventory searches. There's searches incident to an arrest, and that is if you're being arrested, what we call like a wingspan rule, that the police can search the general area around you to make sure there's nothing that would provide a danger to them. There's searches that are based upon probable cause, such as a dog goes around a vehicle and they alert that they've picked up a scent of some kind of a narcotic. Police officer could say that they're searching based upon what they smell. So there's a lot of different ways in which an officer could do a search without a warrant, without consent. Those are all issues that need to be addressed in a courtroom. Do not try to address those issues on the side of the road. It will not work out. Those are issues where your attorney will be addressing those issues in a courtroom. But it's good to know and to be able to make note of that and to be able to tell your attorney when you speak with them that, one, I did not give consent to search, and two, here's the reason that they told me that they were able to search. They were able to search because they got a warrant. They were able to search because a dog alerted. They were able to search because they said they could smell marijuana. They were able to search because they said it was incident to an arrest. They may not tell you that, but they may. You just, under different circumstances. So that's what a search can look like. It can get even more nuanced than that. I told you we could spend hours talking about searches. You can consent to searches. You can consent to certain particular searches. It's okay to, no, you cannot search my vehicle, but you can just search that bag, or you can search the entire vehicle but that bag. There are, searches whether or not it's the vehicle itself, and there's searches of you as a person, whether or not they can search you. We talked earlier in episode 2 about a pat down, how they can search, pat down and feel for weapons for their own safety, but not for evidentiary value or items that might tend to prove something illegal happened. So it's complicated there. A purse or a piece of luggage would be something separate from the vehicle. Searching your phone would be something separate from the vehicle. What I say separate is, for example, a police officer could say, I smell marijuana, and that might give them probable cause to search the vehicle for the marijuana, but it would not necessarily give them probable cause to search your phone, unless they could articulate some reason why they connect your phone with the smell. So it gets very detailed and very granular, and those are all issues that will come up, and your attorney will be able to defend. But that's a topic that a lot of people are interested in, and they want to talk about is searches and seizures, and it is a very interesting topic. I have to admit, it's one of the areas of law that I've spent a large portion of my career and my time, both when I was a prosecutor for the state and as a defense attorney, focused primarily on criminal defense work. The area of the Fourth Amendment protections and how that plays, very, very specific to exact circumstances. So again, your attorney will be able to kind of dive into that with you, but it's important to know your rights. It's important to know that you can say no to a search, that you can not consent to a search, and then that forces the police to come up with another reason to be able to search within the guidelines of the Constitution. So that's searching in general. On any kind of not just police encounters with a motor vehicle, but in a lot of other areas as well. The same laws that apply to you and being able to say no to a search apply at your home, as well. Other things that are related to search and seizure would be questions that you might get about currency. And this has become more and more popular, and I think this is something that's very challengeable, and we're starting to see some challenges to it in the court system. But it's become very common for law enforcement to begin to ask about large amounts of currency. Do you have any large amounts of currency in your vehicle? And of course, my advice to you is going to be to not answer those questions. What they're trying to prove when they ask those questions is they want to know if you have a large amount of currency, and then they will articulate that they believe that you possessing a large amount of currency is indicative of or shows signs of that you're engaged in some kind of illegal activity. I think that's completely bonkers. I believe that people should have the right to carry around as much currency as they want to. And I've defended many people who had legitimate reasons for carrying currency around in their vehicle. They were going to buy vehicles, or they were moving from one state to the other, and they wanted to have money in order to establish themselves when they first moved to the new state. There's lots of reasons to be able to have currency, but that doesn't stop law enforcement from using that as some basis for criminal activity. So again, I advise when asked that question, the answer should be, that you don't want to answer that question, that you've been advised to not answer that question, and not to answer that question and volunteer that information. So what else, other than search and seizure, what other kind of advanced issues present themselves whenever you are encountering law enforcement in a vehicle? One of them might be, if you're under suspicion for driving under the influence, you may be asked to exit the vehicle and participate in what is referred to as a standardized field sobriety test. We've all probably have passed people on the side of the road, and you see somebody out there, walking, and the officer's got them out, and maybe they got a light, and they're doing this with their eyes, and those are typically going to be standardized field sobriety tests. So what is a standardized field sobriety test? Well, it's a battery of tests that the officers conduct in order to give them proof or evidence that tends to prove that somebody's under the influence. Any one of those tests held in isolation is not very accurate, but what the courts have upheld is that when you do a series of those tests, that the aggregate results could give some indication. So it's not about just the one single test, it's about the aggregate of all of them. Types of tests you might encounter or might be asked to perform would be like a 9-step walk and turn, where you're asked to walk in a straight line 9 steps, turn around and come back 9 steps. Another one is we call the horizontal gaze nystagmus, or HGN test, and that's where the light, and they're having you basically have your eyes go over to the edge. And what they're looking for, they're looking for a smooth pursuit, but they're also looking for any kind of a jumping of your eye, a twitching of your eye under those circumstances. And then there's a one-leg stand where they ask you to lift your one leg up and for a period of time to see if you can maintain balance. And there's one called the Romberg test, where you close your eyes and you tilt your head back and you estimate the passage of a period of time, like usually 30 seconds. And they want to see whether or not your time and recognition is on track, whether or not your world is slowed down or sped up based upon some narcotics. And so those are just some of the examples. Sometimes they'll have you do things with your fingers or alphabet and such. But those are the tests that they generally conduct. One of the most important things to know if you're ever asked to perform those tests is that if you have any physical ailments, injuries to your legs, problems with your legs, neurological issues, if you've received any kind of recent injury, those things should be told to the officer before you take the test so they can be taken into consideration. The other thing that's really important, and I see people often run into problems with this, is that they don't realize that one of the major aspects of these tests is not necessarily just how you perform on the test, but how you listen to the instruction and what you say and do while you're receiving the instructions. Some people think, for example, that the 9-step walk and turn begins when you take the first step. It doesn't. It begins the moment the officer begins speaking. They're going to judge that person, that participant, based upon how they're listening to instructions, how they're standing still while the instructions are being told to them, and whether or not they're able to understand the instruction. So, that's just one of those things that, if you're ever asked to participate in a standardized field sobriety test, understand that the test began the moment that they told you that they wanted you to do it, and that if you have any physical ailments or injuries or anything that would explain some limitations that you have, you need to advise the officer of that up front so that they can take those into consideration. Of course, those are usually videoed, and then your attorney can go over with you how you performed on those tests, areas where you might have messed up on the test or might have done well on the test, and you'll be able to go over that specifically with your attorney if you're asked to conduct those. Kind of hand in hand with the standardized field sobriety test, you might be asked about blood draws. And a lot of people might believe, strongly believe even, that they have a constitutional right to not give blood. However, the courts have not agreed with that. The courts have said that law enforcement has a particularized interest in determining whether or not somebody's under the influence, and that a blood test furthers that interest. So, for example, in the state of Tennessee, you can refuse a blood draw. However, the law enforcement can then go get a warrant from a judge or magistrate for your blood, and they can do what we refer to as a forced draw. That is, they can make you give blood and obtain that evidence to use against you. When the lab tests come back, they're either usually testing for alcohol or narcotics. And in the state of Tennessee, for example, they'll just test for alcohol in the beginning. And if your blood alcohol is high enough that it's over the legal limit of 0.08, then they simply will stop testing for economic reasons. They won't test for narcotics. However, if your blood alcohol content, your BAC, is lower than the 0.08 or right on the line of it, where there's maybe some discrepancy about error rates, they will go ahead and test for narcotics to see if you're under the influence of narcotics. And it may be, maybe we think that it's common knowledge, but I've run into a lot of people who are a little bit misinformed about this. I've had several people say to me that, I'm not taking any drugs. The only medicine I'm taking, I was prescribed. And they feel like I can't get a DUI if I'm taking medicine that I've been prescribed. It's absolutely not true. That's an area that will get you into trouble. There are a lot of medications that people are prescribed that when taking it, even taking it exactly as your doctor prescribed, you can't drive a vehicle afterwards. I could not take certain kinds of sleep medicine, for example, and then go get in my vehicle and drive. Even though I've been prescribed that sleep medication and I'm taking it exactly as my doctor has told me, I'm also still under the influence, possibly, from those medication. So if somebody is on medication, especially if it's pain-killing medication, sleep medication, things along those lines that affect the nervous system, then you really should have conversations with your doctor about how they affect your ability to drive, because you most definitely can get a DUI, or DWI as they call it in some states, but DUI, for taking prescription medication exactly how you've been told to take it by your doctor. Matter of fact, in Tennessee, last year we saw for the first year where prescription medication DUIs exceeded the number of alcohol-related DUIs. So in other words, we have more DUIs in the state of Tennessee that are related to drugs as opposed to alcohol. And I know in my practice, we saw that 2 years ago, where we saw for the first time that we had more people who were accused of DUI based upon medication, specifically, a lot of it's prescription medication, some's not, than alcohol. So we see more, drug-related, narcotics-related DUIs now than we do alcohol-related even. So it's a very, serious issue. It's one that I think sometimes people get confused. So it's one of those issues I wanted to bring up today is, absolutely, make sure that you have talked with your physician. Matter of fact, a lot of times you'll look on the bottles and they'll say, do not use heavy equipment, while taking this medication. Well, a car or a truck is definitely heavy equipment. So something that we want to, be aware of and understand as we're talking about this specific topic. And the last thing I just kind of want to bring up in specific topics here is kind of wind down the 3 episodes. We talked about police encounters while in a vehicle. What if you're the passenger of the vehicle? We've been kind of focused on the driver up till now through all these episodes. But what about a passenger? Does the passenger have any rights? Yes, they do. But they don't have the same rights as the driver. For example, if I'm with a friend and we're in their vehicle and they are driving the vehicle, I don't have the same rights to consent to a search or not consent to a search of that vehicle. It's not my vehicle. I don't have the right to allow or consent to a search of somebody else's property. But I do have the right if I have personal items there, a piece of luggage, if a female has a purse, or if I have a briefcase or something along that lines, I would have rights to that item to determine whether or not I would consent or not consent. My phone would be another example. The passenger also has the right, passenger can be asked to exit the vehicle just like the driver and can be patted down just like the driver. However, the passenger can always ask, am I free to go during the encounter? So for example, if a police stop, an encounter with a police officer in a vehicle, and it becomes one of these escalated scenarios where the person who's driving is being investigated further for any kind of criminal activity, and the passenger is just a passenger, the passenger can ask law enforcement at that point, and sometimes it makes good sense to say, hey, I know you're looking into this situation with them, but am I free to go, and extract yourself from that situation. So yes, the passenger has rights. Yes, the passenger is subject to the same kind of safety issues that we talked about in episode 2, but they also have a right to extract themselves or try to extract themselves from the situation going forward. So, and again, a passenger has a right to remain silent just like the driver, and I highly recommend and advise them to do so. They have a right to Fourth Amendment protections against unreasonable search and seizure of any personal items that they have, phone, purse, briefcase, luggage, things of that nature. And they also have a Fourth Amendment right protected against unreasonable search of their own person. And of course we talked about the pat down and how that is a search for weapons, not for evidence. So yes, the passenger has rights, but the passenger's rights are a little bit different than that of the driver. I hope this episode and this series in general has kind of helped to explain, the issues that you might run into, the laws that govern, and the constitutional rights that might be present whenever you have a police encounter in a motor vehicle. And as I said in the last episode, I hope this is a conversation that help inform people to make them less nervous when they are in this kind of a situation where you know what your rights are and you protect those rights, but also for young people who are just beginning to drive or who've just started driving to be able to understand what they're supposed to do in these scenarios, and that way they feel more comfortable if they are in a situation where the blue lights come on behind you, you know a little bit more what to do. So I appreciate you watching this video and this series. Of course, I'd ask that you follow us here on YouTube, that you subscribe, hit the icon and subscribe to our videos as we put out other topics dealing with constitutional rights issues and legal issues and information. And that way you'll get notified when we put out other videos. And again, I just really appreciate your time and hope this has answered some questions. And if at any point you need to ask me additional questions, then feel free to reach out, leave a message here. We're on Facebook as well. We have a website. Again, it's the Law Office of Fry, Knight, and Looper. And my name's Brett Knight. Thank you very much. Hey everybody, I'm Brett Knight from the Law Office of Fry, Knight, and Looper. We hope you've enjoyed watching these video episodes. We just want to clarify and make sure that everybody understands, the legal disclaimer that we always put on these videos, that these videos are put up there for information only. It's not legal advice. And the reason you can tell that it's not legal advice is, in order for us to give you legal advice, we'd have to be aware of your very specific and particular circumstances so that we could advise you based upon those circumstances. The law has a lot of gray areas, and unless we know those specific things going on with you, we can't really give you legal advice. So these videos are for information and entertainment only, and of course are not legal advice. And anybody watching these videos, that doesn't create a client-attorney privilege between us. That's something that would have to take place in our office. And of course, if you ever want to reach out to us and to get specific legal advice, you may do so. However, these videos are not meant or created to do that. Take care and have a great day.